got a midterm today, though.
And we'll take care of that at lunch and everything.
Yeah,
Okay.
I'm super excited about that.
It's cool. We can review it and look at it, critique it, change things. Huh? What?
Oh, he's
The
talking about
video.
presentation. We can make sure we get Mark's good side.
Oh, look what I got.
I got two good sides.
I got one.
Just in case, I don't know how many people are looking at the videos, but all the videos have been uploaded to YouTube. All you have to do is to go to the MSRED channel, and all of them are there. They're all identified by the course number and the date and that sort of thing. So you can view any of them for obviously the past, whatever, 3 or 4 or 5 weeks, I think, for the class. So all that, I'm not sending out updated emails, it's all right there on YouTube for you to be able to kind of access on your phone or iPad or computer. Okay?
Yeah, I got it. Don't worry.
You got it? You got it.
All right. I never printed
You need the cameraman.
Yeah, yeah. So when we do our presentations, guys,
Like the paper ran
I'm
out.
the what do they call it? I was gonna call it a choreographer. I'm the cinematographer, guys.
Choreographer, we're doing dancing.
Yeah, dancing too. Cinematographer and the choreographer.
We got Spielberg over here.
Yeah, yeah. I want an Emmy after this. I'm telling you.
We'll hook you up.
I gotta vote for my Emmy.
I'll hook you up with the Emmy, don't worry. You didn't print out the whole one? Epilepsy is a horrible disease.
Don't say it too loud. I'm on camera.
Survive. Do you like candy? Do you like candy? What is your name?
Kathy. Yeah, I don't think you have.
Who did he say was Kim?
No, it wasn't Kim. It
No,
was
that's the point. He's convinced me of a Kim. I'm like, who's Kim?
Kim. Kat. No, I'm kind of.
Oh my God. He's like, oh yeah, that's a Kim.
I'm saying, if you look at it, the comparison is it all ends with E, right? Emily, Kathy, Kimberly.
How many days you got that?
Oh, 42.
42 days.
This is it, right? Is this one? You can't borrow.
You gotta. What is this?
Oh, I brought muffins. Because I was going to give them away because I have a lot.
Okay.
Did you want one? I have blueberry muffins, guys.
Thanks for telling us.
Blueberry muffins. I have 4.
The four top classmates.
No, I just had extra. I wanted to eat them all. So we can bring them to school. Buy one, get one.
What is today? Happy November, everybody.
Happy November to you too, my dear.
Starting with chapter 10.
Who's excited? What's now? 42 days to go.
Thank you.
Sign the paper.
Show everybody my son.
Cute? Robert's cute. What's his name again? Ryan. So cute. Costumes pretty well too.
What'd your kids go to?
No, it'll be the other way around.
That was a Ninja Turtle, like, really roll with. I mean, nice, Mario. Luigi. Yeah, like cowgirl type?
My niece was a princess and I didn't know which one she was. So I thought,
Say like, you know, goes through and goes, I need to put a kind of.
To watch out for traffic.
This, it's not even on the property.
I wasn't there. Oh my gosh, I literally tried to get
Prepared to pass us all on the midterm?
Huh?
Prepared to pass us all on the midterm?
Not quite. We'll talk about that in a minute.
Not quite.
Let me see if we got enough people in here.
Are you killing it?
13. Missing a couple.
Yeah, we got things to do, guys. So,
Yeah, I mean, I wrote like. It's just like, I mean, the wall separates two things.
Okay, folks, let's get started. Good morning.
good morning.
Another pretty day.
Oh, yeah.
Pretty boat show day. I'm sorry you're stuck here.
We're happy to be here.
Oh, what I got. I want to talk a little bit about what we're going to do today before we plow into chapter 10. We're going to have a midterm exam at 3:15. Somebody stop me at 3:10 if I haven't, if I'm continuing to yak on, so I can pass them out and get started. In case I forget to say this, it's obviously a closed book exam. Put your stuff away, put your notes away, close your book. This is intended to get at what's in your head. I want you to know there are 2 questions on the midterm on stuff we're going to cover today. Everything else is from stuff in prior sessions, but there are several coming and a couple other things that I'm going to mention again that we've covered previously. So to the extent that you can stay with me today, I think it'll help you on the midterm. So we'll do that at 3:15. We'll take our regular lunch break, hopefully around 1, and do a half hour. And as to the midterm, when you finish, you go home. If you finish quickly, you get out of here. I'm going to cut it off at 4:30 though. Hour and 15 minutes is plenty. If you're writing more than that, you're writing too much.
No, don't run on the backside.
Okay.
It's not
How many
multiple
total
choice.
questions?
I'm sorry?
How many total questions?
How many total questions? I'm giving you 11 questions and letting you pick one to eliminate. You answer 10.
Okay.
Similar format to our practice test before. I'm going to ask you to write 6 or 8 lines on a question that I'm going to ask you, and I'm going to give you 11, and again, let you trash 1 and answer 10. You'll have an hour and 15 minutes to do it, and we'll talk through all that when we get there, but that's the plan. So, I want to start with chapter 10. Chapter 10 is general contract law, and I don't want to get too heavily into this. General contract law is a whole course in law school. I think the materials go way too far in trying to teach you all about contracts in general. I think my job is to teach you about real estate contracts, but there are some concepts that come out of general contract law that relate to real estate law, and we'll focus on those. The important part of the concept of understanding contracts, though, is to understand how broad contract law is, and that any agreement between 2 or more people on just about anything is a contract. You walk into a barber shop. Either you're offering to pay $20 for a haircut and they accept, or they offer to cut your hair for $20. And now you may counter offer and say, so I'm only good for 18. And ultimately you come to an agreement. But the concept is that contracts are all kinds of little things that you do every day. When you buy something, that's a contract. It's way too all-encompassing for what we really want to focus on in this class. But again, some of the basic concepts that'll be relevant to our real estate contract talk, which we'll obviously do in depth in the next chapter, in chapter 11. There are 5 basic elements to any contract. We're going to talk about each of them. We're going to talk most particularly about the first 2, which are what are really important. The 5 are, and they're outlined in your material, but let me run through them real quickly so we can then go back and talk about them individually. There's an offer, there's an acceptance, there must be some consideration. There are concepts of capacity, but that's pretty weak and rare, and we'll get into that. And then there's a concept of legality. And once again, that's kind of obtuse and not of great relevance, but that's the laundry list of the 5 items. The 2 biggies are offer and acceptance. And we're going to talk about offer at some length, and then acceptance is just as important, but it's a simpler concept. Anytime there's a contract, it starts with an offer. Somebody, the materials call them the offeror, that's not important. Somebody gets the ball rolling by making a proposal to do something or buy something or whatever, with a purpose that if the other party accepts, it will create a contract. So that's what an offer is. It's a proposal that is intended upon acceptance to create a contract. An offer is not an offer unless it's communicated. Any number of ways. Now realize we're talking about verbal contracts here too. Verbal contracts are just as binding as written contracts. A little harder to enforce, but just as valid, just as real. So in order to make an offer, you got to communicate it in some way to the other party. The way you communicate it is not significant. It allows it to be accepted in the same fashion, but other than that, it does not affect the validity of the offer, but it is not an offer until it's been communicated. That's the only point. There are methods of terminating an offer. And a couple of those are important. And the first one, and most people don't know this, is that an offer can be revoked at any time until it's accepted. A lot of people think, hey, I offered to wash his car for 20 bucks. I didn't hear from him. I'm stuck offering that. I got to wait for an answer. Nah. Anytime you make an offer, you can revoke it, right up until the time it's accepted. Obviously, when it's accepted, you got a contract. So then you can't revoke it. You got a contract now. But remember that right up until the moment of acceptance, an offer can be revoked. Now, another thing that terminates an offer is obviously rejection. If the person to whom the offer is communicated says no, rejects the offer, well, it's over. That terminates the offer, all right? But what happens a lot of times is a counteroffer. Two things about a counteroffer. And of course, I'm sure you realize what that is. Offer to buy your car for $600. You counter back, nah, $650, $700. Counteroffer does two things. It rejects the offer. It says no to the original offer. And a counteroffer is an offer. You're starting over again. The parties have flipped. The person that makes the counteroffer is now the offeror. But again, those words are stupid. But that's the person then making the proposal, is the person who's made the counteroffer. So that's a new offer. So those three things can terminate an offer. Can withdraw it, can be rejected, or it can be counteroffered. There are a couple other things that the materials talk about that are pretty absurd, and we're not going to get into them. You know, what if somebody dies? Does that revoke an offer? Obviously, but that's not. That ain't going to happen to you, probably.
Just a quick question on that.
Yeah.
If it's a company making an offer,
Not going to die.
yeah, so that doesn't have to. So if the person who
Oh,
made the offer,
I imagine if the company that made an offer filed bankruptcy, that would revoke an offer. If the company were dissolved, that would revoke an offer.
so when a person,
But in that sense, we're talking about individuals as to the death. There's one other concept, though, and we're gonna deal with this. Obviously, much more particularly as we get into real estate contract. But one concept that's really kind of vague and subjective is the concept that the longer an offer remains outstanding without being accepted, at some point it lapses. You know, for years later, probably the passage of time means the offer is revoked. That's not really important, because in most offer situations, you're going to see, in real estate contracts and in other offers, you'll see a deadline. You'll see an acceptance deadline. This coupon is only good until November 30th. You got to accept the coupon by November 30th or it's revoked, but it's a deadline. That'll revoke an offer. You're going to find that in real estate contracts, when somebody makes an offer to purchase, they usually put an acceptance deadline. They want to know, do we have a deal or don't we? Let me hear from you. It's good. It's good business practice if you make an offer to put an acceptance deadline in. If you don't, well, maybe someday it'll lapse, but then you don't know when. But as we talked about, but you can always revoke it, anytime. Now, if an offer has not been revoked, or rejected, or counteroffered, it can be accepted. That's the second important concept of contracts. You gotta have offer, and you gotta have an acceptance. I accept your proposal. The instant that there is an acceptance, a contract is created. That's when you have a contract. After offer and acceptance. Now, the materials talk about a couple other things as to what else you have to have a contract, and we'll touch on those in a minute. But the traditional concept in the law is that if you have a valid offer and a valid acceptance, and what the court law calls a meeting of the minds, do the seller and the buyer, do the offeror and the offeree, have a meeting of the minds. Do they both understand what we're doing here? Are we both agreeing to the same thing? And then there's a whole course in, you know, what about this guy made a mistake, or that guy, or fraud, or coercion, or duress, and all this kind of crud. It's not worthy of getting off into all that stuff. If you have a meeting of the minds where the parties understand that this is what we've agreed to do, you have a contract. Now, there are three other things that the text says are important considerations in a contract, are important elements of a contract. They are likely going to exist anyway. but you gotta have them. The first of those three is consideration. Now that means some sort of promises to support the agreement. I'm going to say this now, and I'm going to say it 3 or 4 more times as we get into the other stuff. That does not mean a deposit. A deposit is nice. That reflects some consideration, but it is not important. And you hear all the time, oh, it won't be binding if I agree to buy your car unless we have a $10 deposit. That's crap. Likewise in a real estate contract. A deposit is a wonderful thing, and there are a lot of reasons to do it, but it's not required for consideration. The consideration in a standard real estate contract is, I, the seller, promise to sell you my property upon these terms. And the buyer says, I promise to buy your property upon those same terms. That's consideration. A promise is consideration. A real estate contract is 2 promises. And then we get off into all this crud about a unilateral and a bilateral contract, and it's all bull. I mean, it's nice stuff for law school professors, but it has no bearing whatsoever in my mind of what you're going to be doing. Yes, sir?
Does the consideration have to have an amount?
No, I promise. I promise. There will be a price in a contract. I mean, that's an element of a contract. Of most contracts, not necessarily. Could be, I promise to wash your car if you'll mow my lawn. You know, take care of my cat, I'll watch your dog. Those are contracts without a dollar amount and without a deposit, but they're promises. I promise to do this if you'll promise to do that. And we've had a meeting of the minds, we've had an offer, we've had an acceptance, we have a meeting of the minds, we have a contract, we have consideration because we mutual promises. Yes, sir?
Is a promise in the contract, or is it something that you
It doesn't necessarily say I promise to. I agree to buy your house. That's a
part
promise.
of the contract?
Well, yes, it is. It's set, but just about any contract, although it doesn't say I promise or I agree,
right,
it's in there. It's an offer to perform services or to, that's really the best, I think the best definition I get. Usually it's to perform something. An agreement to perform something is the same thing as a promise to perform something. I agree that I will do so and so.
So
the law construes that as a promise.
Where does it come that people think that you need to put money down to have consideration?
Because they think it's more binding. And it helps show an intent of I meant it. As we'll get off into real estate contracts, we'll talk about all the other reasons why deposits are there. They have nothing to do with the validity of the contract. They have everything to do with damages. And prove, you know, it's a good faith deposit. Show I really mean it. Buyer, show you really mean it by putting up some money. And seller wants you to put up some money because if you don't ever close, maybe you get your money. You know, I mean, there are all kinds of good reasons to have money up there, but it's not to make it a valid contract. Not at all. And I don't know a realtor who doesn't believe that you have to have a deposit to have a valid contract. But it's wrong. You do have a contract upon an agreement to buy and an agreement to sell. Period. Okay. The 2 other things are, you know, you got to have capacity. That means you can't have a valid contract with a child or with an insane person. Parties had to have the capacity to enter into a contract. Now, sometimes the way people act is kind of debatable, whether they were insane when they entered into a contract, but the point is we're talking about legal insanity here, legal incapacity. And know, if you would, in law, underage is called incapacity. You do not have the capacity to enter into a contract if you're 12. Period. The law says you don't. You don't have the ability to have a meeting of the minds and to offer an acceptance contract. And that's why I always talk about contracts aren't enforceable against minors.
Against
But
who?
they're not likely to enter into a real estate contract to sell a piece of property to somebody who's 11, so I just don't think that's a biggie. Yes, ma'am, did you start with a question?
No, I thought you said something, you're not liable to enter into a contract against,
You're
and
not-
I didn't
I'm
catch. You said something and I didn't catch what you said. You said you're not.
You're not able to enter into a contract. The law says you do not have the capacity to enter into a contract if you're underage.
Oh,
Yes, sir.
As an example, I entered into a purchase agreement for a vehicle when I was 17.
Mhm.
Is that something I could have came back, say, 4 months down the line when I was still 17 and revoked it?
All I'm saying is the law will not enforce the contract against you.
So if I walked away from it, I would have been fine?
Yes, it doesn't mean, you might have to fight to get your deposit back, you know, but the courts would not have required you to close that contract because you didn't have the capacity. And that's real debatable now when we get into, is it 18, is it 21, is it drinking age, is it the voting age, you know, but, and in all candor, and I'm not real good on which one it is, whether it's 18 or 21 for these purposes, but if you are underage by law, you don't have the capacity to contract. Yes, ma'am, that's right.
I just have one example. We entered into a contract with a third party and they had a contract with an American company that they failed to check and do partners due diligence. And that company that was a Delaware company was actually dissolved. And it was a big contract that they signed with a brand. And during our due diligence, we discovered that that particular contract was not valid. That company was dissolved. So they entered into a contract with a company that did not exist.
And that's exactly, and that's a good example.
And it's $120 million deal.
A dissolved entity, if you check with the Secretary of State and you find that the entity, and I'm going to urge you as we get into some stuff later, anytime you deal with any entity, LLC, limited partnership, corporation, you always check with the Secretary of State. Not even necessarily in Florida. Maybe you have to check with the Secretary of State in Delaware, as we talked about. Find out if that entity is in good standing, because if it has been dissolved, it does not have the capacity to contract. And that's one of these capacity issues. It just does not have the legal ability to enter into a binding contract.
Now, on that note, if I were to get into a contract and I shipped them out $120 million to perform, and they just disappeared, is that now a legal issue? Where, I mean, a criminal act? Or
No, it's
am I
never a
just-
criminal act. We're talking about civil law here. There are no criminal actions in contracting.
Okay.
It's not criminal for a dissolved corporation to enter into a contract. It's just not enforceable. But there's nothing criminal
So
about it.
if they go away with $120 million, it's just gone? It's a lost cause?
Well, I'm sorry, I didn't get enough.
If I got into this contract with this company,
Yeah.
shipped them out $120 million to perform,
Uh-huh.
and then they disappeared, but they're dissolved, so it wasn't a
It's gonna
valid
be very
contract
hard-
anyway.
It's gonna be very hard for you to enforce your contract. That's all I can tell you.
Okay.
If they were dissolved when it was entered into, you don't even have a contract. If they were dissolved after, then you had a valid contract, but
Yeah.
you're gonna have a bitch of a time enforcing it.
Hmm.
That's all. Now theoretically, there's a concept that a dissolved entity cannot defend itself in court until it's been reinstated. So theoretically, you should be able to file suit and get a judgment against them very easily, but still, we're gonna talk about judgments later. Judgments are often good for wallpaper. You can't collect them, and so what the hell good is it, you know? So you might have the best case in the world, but the other side doesn't have any money, it ain't gonna do you any good. Okay, and the last thing is a legal purpose. A contract has to be for a legal purpose. Well, in real estate, shouldn't be an issue. But a contract for a hit, hiring a hit man, okay, courts are not going to enforce that contract.
Like, hey.
Contract to build a whorehouse, you know? If the purpose of the contract is illegal, all we're saying is, you don't have a valid contract. Doesn't mean it might not get enforced in some other fashion by knee breakers and stuff, but it is not going to be enforced by the courts. Those are the 5 elements of a contract. The 2 biggies are offer and acceptance. The others are just kind of window dressing that you're probably going to have anyway. Okay. Understand that contracts are complicated and confusing, and therefore very often have to be interpreted by the courts. Each side thinks it said very clearly what it was going to do and what it expects the other side to do. And it's astounding how often there becomes a huge misunderstanding and the parties don't agree on what the contract said. And it ends up in the courthouse. There are a couple of rules, the materials talk about them, and these are good rules, and you'll see them used in real estate contracts. And they're just little rules for when there's a conflict in a contract. And there's conflicts all the time. You'll find on page 3 it says you're not going to do so-and-so, and on page 27 it says you have to do so-and-so. And we've got to try to figure out when we have conflicts like that, what's going to control. And here, yes ma'am.
I'm going back a little bit on the consideration part. So we understood that it's a promise. What do they mean with it? I've read somewhere some consideration is expected, so they want me to promise or they want me to give money? Because I understood up till, that some consideration is expected.
Yeah.
So how do you...
A promise is consideration. A promise in the law is adequate consideration.
So for me to...
I promise to cut your hair, you promise to give me $20. But that doesn't mean you had to put down a $5 deposit on it, And it doesn't mean it has to have money involved in it. There are all kinds of enforceable contracts that don't involve money, that don't involve the payment of money. Real estate contracts usually do. You can have an exchange real estate contract where there are no dollars involved at all. I'll deed you my property and you deed me yours. No dollars, no deposit, totally enforceable. For sure. Guaranteed. Forcible, meaning the courts will enforce it. And we're going to talk about remedies of how the courts will enforce contracts. But it's totally enforceable. It is just bunk that you have to have a deposit, either monetary or something else, in order to have an enforceable contract. Mutual promises are it. And most contracts are mutual promises. One person agrees to do something and the other person agrees to do something else. Those are 2 promises. You have a contract. Okay. Now, these little basic rules that come up when you have conflicts in contract are helpful. You don't want to rely on them, but they're there to help you when a problem arises. And they are simply that. Specific provisions control over general provisions. Contracts are full of all kinds of general bunk that people call boilerplate. And as you get further and further in the contract, you find more and more boilerplate. The important stuff is up front. The kind of general garbage is in the back. Specific provisions that say, this shall happen by this date, control over general provisions that say, I agree to do the following. So if you have a conflict on a same subject matter, between a very specific provision and a general provision, the specific is going to control. This is simply how the courts try to interpret conflicts in contracts. Secondly, handwritten provisions are going to control over typewritten provisions. When people write stuff in the margin of contracts, it's going to control over the pre-printed provision. Like when Charlie Crist's staff wrote in, fans will be allowed at the debate. It's a handwritten provision in a pre-printed contract. the handwritten provision controls. Now that assumes that both parties agree to it. It doesn't mean later, oh, okay, I just handwrote something in there and that controls. Both parties agreed to the handwritten provision. It's going to control over a contrary type provision. Yes, sir.
Does it need to be like initial next to that handwritten?
Should be. It's good proof. It's proof. It's better, but it doesn't mean that it's not controlling. If it was in there when both parties signed the contract, then it's just as valid as. Usually you see this initial stuff because contracts are going back and forth and people are writing in this and people are writing in this. And when this guy writes this in, you want to be sure that this guy approved it over here, so he initials it too. That's more evidence of, yeah, I agreed to that part, than it is as to the validity of it.
Okay.
So both parties need to see the handwritten notes?
Say again?
Both parties need to see the handwritten notes?
Yes.
And
Yeah,
approve
oh,
the
yes,
handwritten
yes. A handwritten note by one party later on his copy? We're talking about if a part of the contract is handwritten and it conflicts with type provisions, the handwritten is going to control. That's all we're talking about. We're assuming that everybody has agreed to everything you've seen in a contract and there are conflicts, and now what are we going to do about it? How are we going to decide what controls? When it says Tuesday over here and it says Thursday over here, how are we going to decide which one? Well, if this one's handwritten and this one's typed, the handwritten controls. Okay. Now, same concept, typewritten provisions control over pre-printed provisions. So like in the lease we looked at, and in the contract we're going to look at, if somebody has typed something into a blank, that's going to control over some pre-printed provision over on page 11 that's part of the form. Again, this is, everybody agreed on it, it's in the contract, both sides have seen it, both sides have agreed on it, we have conflicts, how do we decide which of these two controls? Yes, sir?
So in a lease, there's not necessarily a boilerplate lease per se, like everyone does it a little bit differently.
Mm-hmm.
So would it, I guess, everything be a special provision?
Would everything be typewritten? Probably.
I mean,
Then this isn't going to help. These rules, this is not always going to be there. There's not always going to be something handwritten. I'm saying to you, if the courts look at a contract that have conflicts in it and the parties are in front of the court because they have conflicts, these are just the rules that the courts use to try to decide which really mean. Which is more likely to have been the intent of the parties and which are they more likely to have paid attention to and agreed upon, rather than something over here that they probably didn't see, that's been a part of the form for 7 years and they probably don't even know was in there. And similarly, same concept, taking it one step further, an addendum controls over the body of the contract. If you went to the trouble to write up an addendum to say a few specific things, the courts believe you probably meant that, as opposed to even the typewritten stuff in the contract, but certainly more so than the pre-printed stuff in the contract. Now these are just little rules to know that if you get in a fight over something, maybe it'll help you someday to say, hey, look, if we go to court over this, the handwritten part that we both agreed upon, and we both initialed, hopefully, because that's good proof it was always in there, is going to control. And hopefully you can convince somebody that it's not worth going to court to fight over a handwritten change in a contract that both parties agreed to, if that's very clear. Now, if it ain't clear either, well then, then that's what you got judges for. If there is confusion, these are simply rules to help you decide what's the more controlling provision. Okay. I want to talk a little bit about assignment of contract for a second. We talked about assigning leases, and it's the same concept. Remember, we got two parties to a contract, and either party, in a real estate situation, usually it's one, and we'll talk about that, but either party can assign their rights under the contract. That means transfer their rights to a third person. That's an assignment. So, in our sales situation, a real estate sales situation, we've got a buyer, we've got a seller. If the buyer wants to get out, the buyer can assign his rights under the contract to somebody else. The seller now has a contract with that third party. That third party is called the assignee. But the point is, once you have a valid contract, unless assignment is prohibited, and we'll get into all that stuff, usually it is, but if assigning a contract is not prohibited in by the express terms of the contract, then a contract is assignable. So that a buyer can assign his rights to purchase the property to a third party. And the seller now has a contract with that third party. Doesn't change the terms of the deal, doesn't extend the terms, doesn't get to say, oh, I want another 60 days because I'm new in the deal. Nope. Same terms, same timetable, same dollars, same everything. But the seller is now selling to somebody else, unless it's prohibited. And in addition, a seller can assign the contract. Because if, in our real estate situation, during the term of the contract, the seller sells the property to somebody else before he sells to that buyer, that somebody else is bound by the contract. And the contract has been assigned by the seller. There's a new seller, but the seller still has to sell under the same terms. So either party to a contract can assign their rights. Doesn't change the terms of the deal, just changes the parties, and puts the contracting party in contract with somebody else. That's an assignment.
Back to due diligence of that, like if I buy this property, but you had a contract to sell it to somebody else already, am I still bound by it even though I was completely unaware of it?
Go through that again.
All right, you're the buyer.
I'm the buyer.
All right, sorry, you're the seller,
I'm
and you end up selling it to me.
I end up selling it to you, or had a contract to sell it to you?
You sold it to me, but
Have
you
a
also had a
contract-
contract to sell it to somebody else.
I'm not following you. Do I have a contract to sell it to you?
You sold it to me just now. Appreciate it.
I
appreciate
agreed
it.
to sell it to you, or we already had a
You
closing?
just sold it to me.
We've already had a
You
closing?
just sold it to me.
We
But
had a closing?
we had a
close the
closing.
deal?
We had a closing.
Okay,
But you also had somebody else on contract to buy that.
okay.
Am I now bound to that contract for the other person to buy it?
No,
Okay.
no. There are all kinds of issues there of, are people aware of the contracts? People get sued for doing that. But the fact that I had a contract to sell to somebody else can create a lot of problems for me with that other person.
Mm-hmm.
And for you, if you knew about that at all. But if you didn't, and you got a title insurance policy, you're safe.
Okay.
It doesn't happen very often for a seller to assign a contract, but it happens quite often for a buyer to assign a contract. That's what you hear about people flipping contracts in condos and stuff like that. People going out and signing up a bunch of contracts to buy condominiums, but they don't ever intend to close them. They intend to assign that contract to somebody else. And they hope to make a few bucks when they assign that contract to somebody else. However, in most cases, the contract provides they can't do it. Because, understand, if there was money to be made, the seller who's locked into that contract doesn't want you, the spec buyer, making it when you flip the contract to somebody else. He'd rather your deal be dead. And he'd rather sell to that guy for more. So there are all kinds of provisions in contracts that say you can't do this. But, bless you, but number one, that doesn't mean people don't do it anyway. And number two, if there are not provisions that prohibit assignment, then a contract is freely assignable. But understand, it does not change the terms. And when you start into, Robert, the question about after due diligence and all that kind of stuff, a lot of people will say, well, hey, I just got into the deal and it had a 60-day due diligence period. Now I need my 60 days. No. If the 60 days under the contract is run for due diligence, well, that's tough. And you better think about that before you buy an assignment of a contract. don't think the seller is gonna smile and say, oh, sure, I'll wait another 2 months while you start over on your due diligence. No. Yes, ma'am?
How about condo docs? If I bought a condo, I sign it to someone else, does the new person in contract have that 15-day rule to review the declarations?
No,
No?
no. If it's already run by statute, under the terms of the statute that says the 15-day right to cancel period, if that is run, no, it doesn't start over again with a new guy. If he doesn't like the condo documents, well, that's too bad. And that's fair. It shouldn't, the seller of a condo shouldn't be subject to that again and again and again with this idiot and that one and that one. Oh, what do you think of the documents, you know? Yes, sir?
Have you ever seen a case where a commercial building has been assigned, a contract on a commercial building?
Where a commercial building has been what, I'm sorry?
Assigned to a contract on a commercial building?
Uh-huh.
Have you ever seen a case where that's been assigned to someone else?
Absolutely.
Yeah?
Oh, yeah.
That, huh?
Sure. And sometimes contracts provide that they are assignable with seller's consent. And sometimes a seller is so anxious to sell that if a buyer insists on it, a provision that gives them the ability to do it, that the seller will agree to that provision. Because frankly, if you're getting all cash as a seller, theoretically, who cares? Who do I care who I'm selling this to? If they're giving me $1 million cash, I'll take his $1 million just as well as I would have taken yours. Assuming, again, it doesn't start over the time periods, it doesn't delay the closing, and there is theoretically the concept that if your first contract was with Donald Trump and he assigned it to somebody less financially capable, you may be less likely to have a closing. And that could hurt you, but that's something you know going in. But this whole concept, and you see people signing contracts in commercial properties saying the buyer is Joe Blow and or assigns. That is the biggest nightmare known to man. And we're going to talk about that in a minute. And I mean, that just opens up a can of worms beyond belief, and it can be a real important concept if the seller is taking back a mortgage from that purchase. My God, what a difference, you know? Somebody really financially strong that showed you their credentials and their financial statement and their bank references, and you're taking his paper, and he assigns it to some joker who doesn't have 2 nickels.
Tire kicker.
Maybe the guy can come up with a cash to close, but you're less likely to get the payments on your mortgage. It can affect the seller greatly, obviously. But the concept is, theoretically, unless the performance of the buyer depends upon his financial strength or in making payments or managing the property, cash is cash, and if you're getting the same amount of money from both guys, theoretically you shouldn't care. But you're going to find very few contracts that say that they're freely assignable. But sometimes it is negotiated as a provision. Okay, now, I just want you to be aware of that concept that contracts are assignable, just like leases were assignable. Breach of contract. So we got a contract, and one of the parties doesn't do what he promised to do. Close on time, that's the biggie. But a promise is violated in a contract. That's a breach of contract. The legal term is an unexcused failure to perform an obligation. But you didn't do what you promised to do. That's a breach of contract. Now we're going to talk about the remedies for breach of contract in a second. But there's one concept I want you to follow called anticipatory breach. And all that means is you don't necessarily have to wait until the deadline on a contract if the other party has already demonstrated that he's going to breach. If you have a real estate sales contract that says closing is due in 60 days, and after 10 days the buyer tells you, I'm going to Tahiti, I'm not buying your property, to hell with you. You don't have to wait 60 days to see whether he shows up at closing. He has demonstrated that he is going to breach, and you can go ahead and take action immediately upon the anticipatory breach of the contract. Some contracts are performable over a long period of time. A year. If a month or two into a one-year contract, one of the parties does something that demonstrates that he is going to default, if you have a one-year contract to sell real estate, and a month later the seller has sold the property to somebody else and who has knocked the building down, well, you don't have to wait a year to sue that guy for it. Performance may be due later, but you can breach earlier than when performance is due. And that's called an anticipatory breach. Now that's it. So now we have a breach. What are we going to do about it? What happens if a party breaches a contract? I want to tell you now, first and foremost, by a long shot, the most important remedy for breach of contract is specific performance. Specific performance is huge. And it makes sense. And it kind of is exactly what the words say. The court orders the defaulting party to perform the contract as he agreed to perform it. The court orders that you specifically perform your obligations under the contract. This is by far the most satisfactory remedy, the most important remedy, and it gives you what you agreed to get in your contract. It gives you the benefit of your contract that you're not getting because the other side defaulted. Now, yes, sir.
Now that makes sense in a selling situation, but more so if I contracted somebody to perform, say a contractor to perform, and they didn't want to do it for some reason. Would I really want them to still be forced to do it?
No. So you don't sue for specific performance. Okay.
No.
You either choose not to sue and say to hell with it, I'll get somebody else, or you sue them for the second thing, which is damages.
Okay.
But we'll come to that. The second remedy discussed in the contract, in the book though, and this is pretty obvious, but the term for it is rescission. Rescission is, Your Honor, please cancel this contract and put both parties back in the position they were in before we entered into the contract. In a real estate situation, cancel the contract. As seller, free me of the obligation to sell to this guy. As buyer, free me of the obligation to buy this guy's property. The word rescind, you know what rescind means? Rescission. Rescind the contract, terminate the contract, but put the parties back in the position they were in before they entered into the deal. Now, obviously in that case, the contract is terminated. Remember in our first case, of course the contract is in effect. The court is ordering you to perform the contract in specific performance. So of course, the court is upholding the contract and telling you to do it. In this case, the court is saying, let's tear up the contract, but ordering whatever it takes to put you back in the position you were in before you entered the contract. Give him his deposit back. Turn his property loose, free his contract, free his property of the contract and the obligation to sell to this guy. Get them both back where they were before we entered into this deal. Because sometimes there has been part performance. Sometimes the part performance isn't a payment of money.
But wouldn't this be a little bit more difficult in terms of, for example, if let's say you've been back and forth with this person for like a year, and you're trying to sort out, but at the end of the day you say, oh, what, this is not going to work, we both need to walk away, we both need to be put back in the exact position that we were in.
It can be very difficult.
That's what I'm saying, as it relates to,
doesn't always work.
especially as it relates to finances, because let's say your $100, if you paid $100 for the property, would have been worth X amount had you had it in your hand as against having paid over to the seller. Can people negotiate for that?
Sure. Well, and they might have, maybe should have had interest. You know, I mean, all these things are concepts that figure into damages, which we're going to talk about next. But the court concept of the remedy is rescission. It doesn't always work. It's not always appropriate. But it is a remedy that you can ask for if you want it and if it applies to your situation. It's one of the three types of remedies for a breach of contract. Go through with a contract and specific performance, order me to do it, order both parties to do it, kill the contract, pretend it never happened and put both the parties back where they were, or third, damages. Damages are an award of an amount of money to a party suffering a loss because of the breach of contract. How much did the value of my property go down because I wasted a year screwing around with you that didn't close? Or to the buyer, when the seller doesn't close. How much did the value of the property go up in that year that would have been my benefit if you had closed? How much money did I spend on surveying and my attorney's fees and my engineering and my planning and my architect? And then seller, you still don't close and I spent all this money planning a building on this piece of property? Those are damages. And those are called actual damages. Also called compensatory damages. These are real damages, out of pocket, or provable of monies lost as a result of somebody's breach of contract. Actual damages or compensatory damages. Now, in addition, there's one other kind of damages if somebody's been really bad. Flagrant, awful default under a contract, doing something that, as the court says, shocks the conscience of the court. Such bad fraud, such bad illegal conduct that the court says that we want to award, and we're going to talk about this some more later, we want to award punitive damages. And we're going to talk about that later when we get into fraud, because if there's really bad fraud, there's a type of damages called punitive damages, and that's to actually punish a party for being so bad. Much more than the amount lost by the injured party. Let's give them some more money to punish the bad guy. Sometimes it's hard to prove your damages. And the courts, if their conscience is shocked by somebody's conduct, will award punitive damages. Now, you'll see in real estate contracts a term called liquidated damages. And liquidated damages are an amount of damages that the parties in advance agree to in their contract. A fixed sum of damages. Here's the concept. Parties enter into a contract and they agree in advance that if either party defaults here, it's going to be real hard to figure out what the actual damages were. So let's both agree that if either of us default, the damages will be $10,000. A fixed sum. Liquidated damages for damages that may be hard to prove as actual damages. Parties agree to a fixed sum in advance in the contract. This is the amount of damages that will be available if I default. And that doesn't necessarily go both ways. Yes, sir.
Similar to like a, well, I guess you're still continuing the contract, like a per diem? A per diem?
A per diem, you can do that.
So, what's
A
stated
per
amount?
diem, a per diem penalty in a construction contract is liquidated damages.
Same thing.
We have agreed, it's hard to prove what my damages will be for each day you delay completing my building, so let's agree in advance, it's $1,000 a day.
Right.
That's a good example of a liquidated damage provision. The one we see most commonly is in real estate contracts. And this comes back to, again, the buyer's deposit. You'll find, and we'll see when we go through a contract, the parties agree that the buyer's deposit is a liquidated damage amount to fairly compensate the seller in the event the buyer defaults and doesn't close. It's going to be hard to calculate the seller's damages. Did the value go up or down? Did I move out of the house? I have to start over again. It's 6 months later, more real estate taxes, more insurance. It's going to be real hard to calculate all that, so let's agree in advance here, Mr. Buyer. If you don't close, you've put down $10,000, that's a liquidated damage provision, I get your deposit. That happens all the time, and the courts will enforce it. And that, frankly, is the biggest reason for a deposit in a real estate deal. It's to ensure the seller that the buyer has put up some money to compensate the seller for taking the property off the market and maybe missing some other deals and maybe moving out. It's a fixed, it's a pre-stipulated sum of damages in a contract, and that's liquidated damages. Okay. The text then goes into a whole section on discharge of a contract, and we're not going to go there. There are some very complicated concepts in here of novation and accord and satisfaction. You're not responsible for learning those things. They're way over the top in terms of contract law. They're not really real estate law, and you're not responsible for them.
From discharge onwards?
I'm sorry?
From discharge onwards?
I'm going to tell you about two things about discharge that you are responsible for, but what I'm saying to you is those three concepts of novation, accord, and satisfaction you are not, because they are way too deep. There are two ways you can be discharged from a contract. Very simple, by operation of the parties or by operation of law. Operation of the parties is something that the parties do to discharge a contract. Let's both agree to tear it up. Realtors aren't real big on that when buyer and seller agree on that. But the parties together to a contract, unless third-party rights are affected, can agree to kill a contract. Or maybe both sides have already performed. Well, that discharged a contract. It's over. Both parties have performed. But that was something the parties did. The other way that a contract can be discharged is by operation of law. operation of law is something that's not done by one or both of the parties to the contract. Such as a house burned down. Was a contract for a house and it's gone? Well, that sure changes the nature of the deal. Now, there are provisions in a contract that talk about what happens. But if there weren't provisions in a contract, the courts say, by operation of law, if basically the whole purpose of the contract is frustrated by a damage to the property or by passing a law that something became illegal. Let's say we signed a contract for you to build a movie theater here under a land lease on a corner here. And then the city commission passed a law there'll be no movie theaters in Fort Lauderdale. Well, the contract has become unenforceable because it's illegal, but that's later. That's after you sign the contract. You remember we talked about an illegal contract going in. That's if something was illegal when you agreed to it. It's not a contract. We're now talking about afterwards. You had a valid contract. What if the subject matter of the contract becomes illegal? That's a matter by operation of law. The only important concepts here to realize are discharge of a contract can happen by operation of the parties, by something the parties do, or by operation of law. And that's it. And that's all I have for you on Chapter 10 on basic contract law, and that's probably more than you'll ever need to know. But it's a lot less than what the materials wanted to cover, and it's certainly a lot less than a comprehensive course on contracts, but that's not what this is. But it is a course on real estate law. And that's why we're going to get into real estate contracts now. We're going to do it at length. And that's Chapter 11. And it's on real estate contracts. And you're going to hear them called real estate purchase agreements, or real estate purchase and sale agreements, and real estate sale agreements, and contracts, and agreements. And it's all the same thing. Please don't think that by any of those titles, that's a different animal. Just a different name for the same thing. And likewise, back earlier when we talked about contract. A contract is an agreement. And those terms are used interchangeably, and I've been asked over the years, what's the difference between a contract and an agreement? Which one should we put at the top here? Whatever suits you best. Doesn't matter. Same thing. Okay, now, we're going to talk about a couple of real basic concepts that relate to real estate contracts, and then we're going to go through at length the form real estate contract that I sent you. A real estate contract or purchase agreement or sale agreement or whatever we're calling it here is an agreement where a seller promises to sell real estate by conveying the real estate by a deed. Seller promises to sell and convey by a deed, and the buyer promises to buy, and pay a specific price. And in both cases, we're talking about for a specific piece of property. Obviously, the property is, we're going to go through the concept of the contract. The property is going to be identified. But we're talking about the seller agrees to sell and the buyer agrees to buy. That's a valid contract if it describes the property properly. No consideration, so separate deposit consideration is necessary. You've got two promises in a contract. You've got a binding real estate contract. Now, we talked earlier about the statute of frauds. The statute of frauds is an old English statute that talked about certain things that have to be in writing. And the purpose is to prevent fraud. Some things are important enough that the law requires, that the statute of frauds requires be in writing. And it In leases, as you recall, we said that any lease over a year had to be in writing by virtue of the statute of frauds. The statute of frauds also says that any contract for the purchase or sale of real estate has to be in writing to be enforceable. Period, unavoidable, unequivocally. You cannot enforce a verbal agreement to buy or sell real estate. By law, it's unenforceable. That's the statute of frauds. Now, what the statute of frauds requires is what's called a written memorandum. And a contract's going to do a lot more than that. But the basics to have a contract that will stand up under the statute of frauds are an agreement in writing that identifies the parties and the property and the purchase price. And there are going to be some other terms, clearly. But lastly, it must be signed, and the concept here is signed by the party against whom enforcement is sought. What that's getting at is, if you have a real estate contract and the seller never signed it, but the buyer did, it can be enforced against the buyer. It just can't be enforced against the seller. Cannot be enforced against a party that didn't sign it. Now, there's a question of how did you ever really have a valid contract there, but it's conceivable that a seller put together and typed up a contract, gave it to the buyer only signed it. So whichever side of a contract you're on, it's a lot more important to you that the other side signed it than it is that you signed it. That's the point. Okay, that's the statute of frauds. Now, the materials get into all kinds of other stuff that we're not going to go there, that are all about the law of evidence. And what kind of evidence can you bring in to prove you had a valid contract? Evidence, likewise, is another huge 6-month-long course in law school on the rules of evidence. We're not going there. And all concepts about what can take an agreement out of the statute of frauds and all. You don't want to be there. These are all the bootstrap things that you try to fall back on if you're screwed up and you don't have a written contract signed by both parties. But these are not things that you're going to want to run your business based on. You want to run your business on sound business practices, which is we're going to have a written, signed real estate sales contract signed by both of the parties. There's one other little side animal I want to bring up now because the materials don't refer to it anywhere. And if we don't talk about it now, it's not going to come up anywhere else. But it's real common in real estate today. And it's called a letter of intent. And lots of deals begin with a letter of intent. You can say theoretically lots of deals end with a letter of intent too, but that's because they never got the contract. The point is, a letter of intent is not a contract. And you're going to see in a letter of intent that it's going to say that about 5 times. At the beginning, at the end, probably somewhere in the middle. Both parties are going to say, there is no deal here until we have a fully executed sale contract. But because in a commercial transaction, sometimes a fully executed sales contract is gonna be 40, 50, 70, 100 pages long. It's awful cumbersome to have to draw up that whole damn agreement to find out if the other side will or won't sell for $20 million. So use a letter of intent to find out. And you as buyers send a letter of intent. Conceptually, here's what it says. It's a letter from a buyer. It always starts out as a letter from a buyer. It doesn't have to be. It just practically, this is how it happens. A buyer writes a letter to the seller that says, would you be willing to sell your piece of property for $20 million and close in 6 months? But the buyer says, but this is not a contract. We're not going to have a contract until we sign a contract, but this is simply a letter fishing for a few of the essential details to find out, do we or don't we want to try to do a deal at $20 million before you write up a 50-page contract just to get a no to that answer. And it's, again, it says all through there, we don't have a deal until we have a deal. About all the law will enforce out of there is, and they won't even really enforce this, but there's almost sort of a moral shame game here. That if you said in a letter of intent you'd take $20 million, you can't later say I want 21 million. If you said I'd do with a year closing, you can't later say, nope, I wanted a 30-day closing. The few, and I mean they are few and sketchy details that you agree to in a letter of intent, all you're saying is those terms are going to be set forth in the big contract when we do the big contract. But before we go to the big contract, can we agree on these basic 3 or 4 things of, will you sell me your land, and will you sell it at this price, and will you give me a 90-day due diligence period and then another 60 days to close? And often those get haggled back and forth and initialed and signed. You go through all the same crap you do in a contract, sometimes months to get a signed letter of intent in order to start drawing a contract. But the concept is, it is not intended to be a contract. You usually in a letter of intent end up with a meeting of the minds. That's the whole idea, like a contract, and let's agree on at least these few basic details. But both parties say, but I'm not bound by anything in this letter of intent, because the seller doesn't want to tie up his property if the buyer never does a contract. And the buyer doesn't want to go through drawing up all this if the seller ain't going to sell to him anyway. So let's agree on these few basic terms. Was there a question there? I'm sorry.
Yeah. When you send in a letter of intent for a property, I mean, you wanted to make it like a binding letter of intent because it reads as a contract. You know, you have that name and acceptance, consideration, a promise, and if it's accepted, by the seller. How do you make a binding or a non-binding letter of intent? Because if sometimes you don't want it to be that binding, and sometimes you prefer to have the seller like a compromise with you. So
there is such a thing as a binding letter of intent, and it says binding letter of intent. Okay. And it doesn't have, yeah, of course, and it doesn't have all the provisions in it that say that this isn't a contract and this isn't binding. Then it is a contract named binding letter of intent. I told you you can name a contract anything you want. You can name your contract binding letter of intent if you want to. If both parties agree to all the essential terms of the deal in there, and it's not full of all this stuff that says, this doesn't count, I don't really mean it, I don't have to be reasonable, and they say stuff like that. They say, neither party agrees to be reasonable when it comes to a contract, because you don't want that thrown up in your face later. Well, now you're acting unreasonable. You say, I'm not agreeing to anything except I am willing to entertain the idea that we go to contract upon the terms set forth here. And it is basically a moral shame game of changing the deal later. The buyer, when you go to contract, it's almost like you said you would, why won't you now? But because they have so many provisions in there that say that this is not enforceable, the courts are not going to hold you to it. And realize, if you would, even if you've agreed in a letter of intent to 7 essential terms. There are another 300 in a sales contract, any one of which you can say, no deal because of that, no deal because of that. Not these 7, but I can find you 100 other reasons as an excuse to say, well, I'm not agreeing because you said the contract wasn't assignable. Except, if I'm answering your question, sure, you can say it's a binding letter of intent, and sure, you cannot have all those provisions in there that say that it's not binding. Then you can have a letter. We have enforced letters. We have enforced letters where a guy wrote a letter and said, I will sell you my property for $500,000 on a 60-day closing, and it will be all cash, and I want a $10,000 deposit. Buyer says, I agree. 1 page, that's a contract, and we've had courts order the parties to comply with it. That's a sales contract. It was a letter on somebody's stationery. Occasionally you hear about them on a cocktail napkin. It can be done. If you cover all the essential terms, both parties sign it, you've set aside the statute of frauds, both parties have signed it, it's a written memorandum that sets forth the parties, the property, a few essential terms, the price, that's a contract. Doesn't have to say, it can say non-binding napkin letter of intent, but if it is a contract, if it is enforceable like a contract, the courts will enforce it.
So the important thing is to write something like enforceable once both parties agree to sign a purchase contract.
Sure, anytime both parties, anytime we talked about before, anytime you have an offer and an acceptance, you have a contract. Unless it's illegal, unless there's incapacity, unless there's fraud, whatever, you have a contract and it is enforceable. But these, a letter of intent always talks about, and this is the fatal thing to where you're going with this, a letter of intent always talks about there is going to be a contract. The minute you say there is going to be a contract, you have said, I don't mean for this to be enforceable. It always says there's going to be a contract later that's going to contain all the essential terms of the transaction, like who's going to pay for the dock stamps, and who's going to pay for the title insurance, who's going to pay for the survey, where are we going to close, all these things that you're clearly not going to say on the napkin, but they're going to be in the contract somewhere. And the minute you say in a letter of any type that there is going to be a formal agreement to follow, it has become a letter of intent no matter what you call it. Because you are saying, this is not our contract, there will be another contract later.
So it's not enforceable?
I'm sorry?
You cannot enforce that letter of intent, even if, because you see in commercial, like if they want to hold on to a property, they send a letter of intent and they offer a deposit of money, within a period of time upon acceptance. So you have to mention the contract, even if you mention the contract after, and the seller doesn't perform. Can you enforce that?
I'm trying to say it again, I'm not sure if I said it 100 times whether we're going to be speaking the same language here. If the document you have contains all the essential terms of a contract, the courts will enforce it, no matter what you named it, as long as it doesn't talk about, of course, as long as it doesn't say it's not enforceable, unless you talk about there's another agreement intended to follow. If you talk about, now we're going to move on to a contract, then you have just said, this ain't it, this ain't enforceable. And I have seen him named binding letter of intent. And the first thing that the other side does is, well, they cross out the word binding and they write in here, and I'm not bound until we've signed a fully signed contract. And if you take him to any lawyer, that's the first thing he's going to do. Unless you were trying to bind somebody. Unless you're trying to let this serve as a contract. But that's not what we're talking about here. Yes, sir?
Sometimes too, if you're building, for instance, a retail space and you're looking for some financing, if you line up 5 tenants and you get like 2 LOIs from nationally rated tenants, the bank is likely to say, okay, that's something we can work with.
Absolutely.
So it could be used more for...
It's as good as the party that signed it.
Right.
And will they follow through on what they said they would, which was, yeah, we agree to enter into a lease with you on the following terms.
So it's more than just spec, you actually have some form of revenue potential.
Absolutely. It's like pre-sale agreements in a condominium where you demonstrate to the lender, I have 8 or 10 of these pre-sale agreements that say that these buyers are willing to sign a contract.
Right.
In those pre-sale agreements, they didn't really say, I will buy, but they say, I will enter into a contract with you with the following price. That's a letter of intent also, is a pre-sale agreement. But I'm bringing it up here because it's not talked about anywhere else in the book, and it's common, and some people think they're contracts, and they can be, but they're not intended to be, and that's not what we're talking about here. We're talking about a non-binding letter of intent, trying to nail down a few of the essential terms to justify the time expense of going to contract, which can be expensive. You can pay a lawyer $10,000 to draw up a contract. And if the other side had already decided, I'm not selling to you because I don't like you, or at that price, you just didn't really need all that to find out, do we want to do a deal here?
Right.
That's why we use them.
It gives you a chance to sort of do some preliminary negotiations with that seller. And like for one example I had where we sent a letter of intent to a seller who I knew this seller, I could agree with him verbally, but he had a partner that he needed to run things by. So they asked, hey, send a letter of intent so I can present it to my partner, and then we can work out the details.
Great idea. Yeah, sure. And to me, I really believe it's just kind of a shame game. If 2 or 3 times you agreed in letters of intent to something and then later wouldn't do them, the word gets around and people quit bothering to do letters of intent with you for sure, but hopefully quit doing deals with you too. It's a sort of a take my word for it thing. It could just easily be verbal. You walk up to a seller and say, would you sell me this thing for $20 million? He says, yeah. Okay. That's not valid because of the statute of frauds, and it's not enforceable. But it's about like a letter of intent. Now let's go to a binding agreement where we both agree and really mean it, and outline the rest of the terms, because there's so many other terms in a contract that cost people money and determine rights and obligations and responsibilities and warranties, and all those things are going to be set forth, and they're all things that a deal can fall apart over too. Okay, now I want to go through our contract. The material, the book, then goes through paragraph by paragraph all the provisions of a contract. We're going to do that after we've been through a contract. I want to go through this first, and then we'll come back and touch very briefly on the rest of the things that the text says have to be in a contract, and you're going to see they were all in our contract. So, if you brought a copy of it, I hope you did. The commercial contract that I sent you a week ago, it's another Florida Association of Realtors form. Once again, provided to us by Town Real Estate, and it's the Florida Association of Realtors Standard Form Contract for Commercial Properties. Realize, if you would, this is not for houses. That's not what we're talking about here. Talking about buying a commercial real estate, piece of real estate. It may be improved, it may be vacant, but it's commercial. And it could be residential property, like an apartment building, but it's not a single family house. Now, Section 1, line 1, the first 3 words here are 2 of the 3 most important things in a contract: parties and property. You got to get these 2 right. If you screw these up, your contract may not be enforceable. Not necessarily won't, but conceivably won't. You clearly want to get the buyer's name right, but triply important is getting the seller's name right. You've got to have the owner of the real estate listed as the seller here. Not just signing later, we'll get to that at the back end, but listed here. You must properly identify the title holder of the property in order to have this contract be enforceable against the owner of the property. And you must have a proper description of the property. That's not street addresses. Street addresses are for the mailman. It's legal description. And we're going to talk some more about this later, but it's the real legal description. We're going to have a whole chapter later on legal descriptions. But what I'm saying to you for these purposes is, and for God's sake, it's not the legal description used by the Broward property appraisers, which 9 out of 10 real estate brokers put in the contract. The property description by the Broward property appraiser on his website is very often incorrect. It might work. If it's platted property, it'll probably work. But if it's meets and bounds property, acreage property, you're going to find a description that is so alien there and so abbreviated there that it's like reading Chinese. Don't use it if you can avoid it. And I'm going to tell you later where to go get the right legal. But the point is, at this point as we go through the contract, I want to tell you that we've just done 2 of the 3 most important things in a contract. Identified the parties and properly identified the property. That's legal description on line 5. Now, and then of course it goes into the personal property and all that kind of stuff. That's not very relevant in a commercial property, but it's in the form. Now, this purchase price stuff in section 2, that's all pretty obvious. And most people think it's the most important thing in a contract. Yeah, it probably is, in terms of what am I going to pay here, or what am I going to get here, but it is not. Nicole, you having a problem? Do you have a contract?
Yeah, we just want to make sure.
I think I printed the wrong one. Because the one I have says contract or residential sale or purchase. You have the commercial one?
I had the same things, we just want to look at the same one.
In our first class, I sent you 2 pages out of the residential contract.
That's
what those were? Okay. This is about a 12-page contract entitled in the upper left, commercial contract. Okay, now, purchase price. It's pretty hard to screw this up. Seen it done, but in the old days, we made them write it out too, like you write out in a check, but people just don't do it anymore. Obviously, you're going to put the purchase price. Concepts now of the deposits. In sections A, B, and C. Deposits are a wonderful thing in a real estate deal. And the real words for deposits that are used to describe them are good faith deposits, earnest money deposits. Now, I'm telling you these because you're going to see them in other forms described other ways, and people talk about them. How much earnest money was up in the deal? How much good faith money did the buyer put down? The concept here and the pitch here is for the buyer to show, I really mean it, here's some money to show I at least have enough of a checking account that I can write a check for deposit. But as we're going to talk about later, it's conceivably the amount of money that is forfeitable if the buyer defaults. That's the importance of it to a seller. How much am I going to get if this guy doesn't close? But, as we talked about before, up in line 2 and 3, we had a contract without a deposit. The buyer agrees to buy, that's a promise. The seller agrees to sell, that's a promise. We had a valid contract without this deposit. But you're going to see them in every deal. And then there's B and C. How about an additional deposit after a few days? And how about an additional deposit after a few days more? If you're a seller, the more the merrier. You want as much as you can. Not only to show the buyer can perform, but also hopefully to give me some money if he defaults. If you're the buyer, you want to put up enough to show that I'm serious and I'm good for it, but no more, because things happen. You get a job offer and you move out of town and you're going to lose this deposit. So I don't want to have any more up there than I have to. So this is a negotiated term. That people haggle over deposits, and they, just like they cross out numbers on the purchase price and change the purchase price, oh, they'll change the deposits. Or they'll change the number of days that it's due here. This is all pretty obvious stuff. D is important. D is total financing. And that's financing in a couple of different ways, and we're going to see in different sections here the different types of financing that we could be talking about here. But what we're talking about is if it's not all cash out of the buyer's pocket. If we're talking about there's a mortgage somewhere of some type, either a new mortgage